everyone, welcome back. So this week we're actually going to move on to the second component of the criminal justice system. So in the last couple of weeks, we've been talking about the organization, administration of policing. So this week we're going to move on and talk about the organization and administration of the court system. Okay, so we're going to break it down into two lectures. We're going to talk about the organization today, and then we're going to talk about rules and regulations for the next lecture. Okay. So let me share my PowerPoint. So some of this is probably going to be a review from intro, just like some of the policing stuff was probably a little bit of a review from intro. And we're going to look at the ideas of how the court system is organized and how it operates. Okay, so that's what we're going to study today. So my first question is to get you thinking. So what do you think, true or false? There are two kinds of courts in the federal court system, the trial courts and the Supreme Court. So hopefully you know the answer to this from taking your intro course. But how many different courts do we have in the federal system? And hopefully you say 3. Okay, we have trial courts, we have appellate courts, and then we have the highest court in our system, the Supreme Court. So hopefully you remember that. Now, what we're going to talk about is how courts are organized and how they came to be. So the first question is, what are the 3 branches of government? So I keep asking you, what are the 3 parts of criminal justice? And we said police, courts, corrections. But let's take a step back. What are the 3 parts of 3 branches of the federal government? So when we talk about what makes up our government, there are 3 branches. So we have the executive, we have the legislative, and we have the judicial. Okay, so which one of those 3 is in charge of our courts? It's the judicial branch. So it's important to remember when we're talking about the judicial branch that the judicial branch was created by Article 3 of our Constitution. So that's what makes up our judicial branch. Okay. Now, what Article 3 actually says is that has the judicial power of the United States shall be vested in 1 Supreme Court and in such inferior courts as Congress may from time to time ordain and establish. So if you read this very carefully, it tells you that the Constitution only requires 1 court, the Supreme Court. And then it gives the power to the legislative branch, Congress, to decide what other courts should exist. But a strict interpretation of the Constitution says that the only court that has to exist under our Constitution is the Supreme Court. What happened was, though, that Congress passed a law, the Judiciary Act of 1789, it was signed by George Washington, that created lots and lots of more courts. Okay, so we have the Supreme Court created by our Constitution, and then we have this Judiciary Act, which created all the other levels of courts. So the district courts and the Court of Appeals, our immediate appellate courts. Okay, so those were all created by the Judiciary Act. Now, when we talk about the parts of the criminal justice system, we say they are all organizations. So as a quick review from the very beginning of the class, we want to talk about what do all these organizations have in common. So we talked about that they all have members, they all have clients, they all have structure, they all have a purpose or goal, which we said is their mission. They all have functions and duties that they have to carry out so they can meet those missions. And then they have organizational guidelines. Okay, so we're going to look at each of these as it relates to the court system. Okay, so who are the members or the players in the court system? So who are the people that actually work in the court system would be who are the members. Okay, so if you think about it, who do you think works in the court system? Hopefully, again, it's a review, and you know there's lots of different people that work in the court system. So you have judges, you have prosecutors, you have defense attorneys, you have bailiffs, you have stenographers, court reporters that type everything up, and you have court clerks. And now, obviously, there's lots and lots of other people. You have court officers, and there's lots of people that are in the courtroom. But for our purposes, this is the basic members of our court system when you're talking about the criminal justice system. Okay, so now we have to think about who are the clients in the court system. Who does the court exist to help? And I would say it's the citizens, just like a lot of the different things that we've talked about. The citizens are the clients. These are public organizations. You work for the government, and so they are there for the citizens of that government. Now, what is the structure of the courts? Again, I hope this is a review. When you talk about the court system, remember in this country, we are what are called a dual court system. That means we have two sets of courts operating next to each other at the same time. So they literally operate next to each other at the same time. So we have the state court systems. We have all of the different various state courts. And then we have the federal court system and all the different various federal courts. So these two separate court systems operating next to each other at the same time. They're completely separate from each other, and they both have different ways, cases that they handle and different manners that they handle them. Now, on top of the whole thing, sorry, I got to sneeze. Okay, didn't come. Okay, on the top of both courts, at the very top of our whole court structure, we have what's called the Supreme Court. So Supreme Court is the supreme decision-making body of the whole court system. They're the top one. They have top authority. And they have final authority over state court decisions and also federal court decisions. Okay, so I have posted the structure of the courts crash course. I strongly recommend you stop the video, go and watch it. I can't always play it during the lectures because then they say that I copyrighted. So I posted it in the class, so make sure you stop and watch that. It's a really good review of the structure of the courts. You need to remember how the courts are structured and the different levels of courts that exist. You need to remember that. Okay, now just as a quick review, in general, most courts are structured in this way. So you have the lowest court, which are the trial courts. Sometimes they call them the inferior courts. They are the courts of what we call original jurisdiction. So that means they are the courts that first hear the court cases. They're the first ones that get to decide the issue. Now, when you're talking about the court system, they're the ones that really have the jury. So when you see things on TV with juries and making determinations, those are courts of original jurisdiction. General jurisdiction means that they can hear all various topics. They're not separated out by specific topics. The next level is what we call the appellate courts. So go back, in the trial court, in the federal level, it's called the district court. In New York State, it's called the Supreme Court. Then we have the appellate court level, which is the middle court. So if you don't like what happened at the trial court, you can always ask the next court up, the appellate court, to hear the case and see if any errors were made at the trial court. So they review what happened at the trial court and make sure that there's no legal errors. They don't have juries. They just read the transcripts created by the court reporters and then see if there were any problems at that trial court. The federal system, we call this the Court of Appeals. In New York, we call it the Appellate Division of the Supreme Court. And then each court system has its highest courts. Oftentimes, these are called the courts of last resort because they are the last court you can go to. There's nowhere higher. They generally have appellate jurisdiction, so they're going to hear cases from the appellate courts that get appealed higher. Generally, they're only going to hear cases that have significance to the whole state or to the whole country. They're not going to decide more minor issues. They're going to look at constitutional big issues and only take those kinds of cases. Remember, in the federal system, it's our Supreme Court. In New York, our highest court is our Court of Appeals, okay? And these have what we call limited jurisdiction because they only hear appeals. They're not hearing the original cases. Now, just as a review, let's talk about the idea of jurisdiction. So we've talked about jurisdiction when we talked about policing. And remember, jurisdiction is the geographic area where you can exert your authority. In court terms, there is multiple types of jurisdiction. So general jurisdiction in court system means you can hear any kind of case. You could hear a case about a will. You could hear a case about a contract, about buying a house. You could hear a criminal case. And then you have what's called limited jurisdiction. Limited jurisdiction is when certain courts can only hear certain things. So when you think about what I just showed you in the previous slide, the trial court is the first court that has the jury trials. They are general jurisdiction. They can hear anything. But when you go to the higher courts, they can only hear cases that have been previously decided in the trial court. So the two higher courts are the courts of limited jurisdiction because they are limited to only hearing cases that have already been decided, okay? Now, jurisdiction is really important when you're talking about the court system because it limits a judge's power. A judge cannot hear a case unless it has jurisdiction over the matter. So that's a legal thing. Unless the court has the authority, the jurisdictional authority to hear the case, they cannot hear the case. So you cannot bring a regular criminal trial to the Court of Appeals in New York without first going through the others because they are a court of limited jurisdiction. Now, we also divide jurisdiction by geographic area and subject matter. So geographic area is what are your geographic boundaries. So if you are a county court, you can only hear cases in that county. If you're a state court, you can only hear cases in that state. If you're a federal court, you can only hear it in your federal district, right? So you're limited by geographic area. Another way that we separate courts out is what we call subject matter jurisdiction. There are certain courts that can only hear certain subjects. Okay, so in New York, we have county courts, and county courts only hear criminal cases and then minor civil cases. We have surrogate court. Surrogate court hears cases dealing with wills and trusts and estates. We have family court. Family court hears juvenile crimes. They decide paternity issues and child support issues and child custody issues. Those are the only kinds of issues they're allowed to hear. So those are what we call subject matter jurisdiction. There's some courts that can only hear cases on very specific subjects. So when you talk about jurisdiction with courts, you have to figure out first what court has geographic jurisdiction and then what court has subject matter jurisdiction. Okay, now the purpose or the mission. So what is the constitutional purpose of courts? So we said our government's made of three parts. One of them is the executive branch, and the Constitution created the Supreme Court. But why? Why did the Supreme Court get created? What was the purpose the founding fathers were trying to satisfy with the courts? So we know the executive branch was to enforce the laws. The legislative branch was to create the laws. So what was the constitutional purpose of the judicial branch or the court system? And it was to interpret the laws, right? So we have one branch that creates the laws. We have one branch that's responsible to enforce them. And then we need a third branch that researches them and looks at them and interprets them and figures out what they mean. Okay, so the purpose of the judicial branch is to interpret the laws and the Constitution. So this is just to get you thinking. So does the judiciary have the ability to enforce its decisions? So this is interesting. If a court makes a decision that something is the rule, how do they enforce it? Do they have their own police that go out and make sure that their decisions are followed? Do they have a military? Do they have any enforcement part of it to make sure that people are following what they say? And the answer is no, there is no special enforcement. So our whole system is based on what we call rule of law. Rule of law is the idea if a law is fairly created and fairly applied, then everybody just agrees to follow that rule. So the judiciary branch itself does not have any way to really enforce its decisions. But our whole system is just based on this foundation of rule of law. It's the only way our society, our government functions. And so everybody has a sort of agreed upon pact in society that if the court says it, we are going to do that if we think it's fair and it's reasonable. Okay, and that's how our system works. Now, what is the duty or function of the judiciary? So we said its mission is to interpret the laws. What is its main duty and function? It is to obtain justice, right? So that is why our judicial branch is often represented by a balance, because justice is balancing multiple things and coming up with the most fair decision. So justice is often defined as fair, right? Ethical, moral fairness. So that is the purpose of the judiciary, to interpret the law and determine what is just in the law based on the interpretation of the law. Okay, so seeking justice or obtaining justice is the main duty of the judicial branch. Now, to get you thinking about this concept of justice, I want you to think of Lady Justice. So I don't know if you know what Lady Justice is. She's a woman, she's holding something and something's on her face. And so think about it. If you can think of Lady Justice, how would you describe a Lady Justice? See if you can picture her in your head. Well, this is Lady Justice, right? So she's standing on a book, she has a sword, she has a balance, and she's blindfolded. So this is considered the symbol of justice in our country. So what does this mean? How do we define justice based on this picture? So when we think about Lady Justice, this is basically what it's meant to be. The scales represent impartiality and an obligation of the law to weigh each side and be fair. The sword is enforcement. So their decisions and their rulings are being enforced, right? And then the double-edged blade signifies that the rule can go either way. So it could go for the prosecutor or the defense. It always can go either direction. The blindfold is supposed to mean that it's impartial. Justice is impartial. It's not supposed to favor one party over the other. So when we think of the court system and we think of the term justice, these are the concepts that we think are fundamental to maintaining justice in our society. And that's why she's a symbol of our judiciary. So what is justice here? So we know generally it should be impartial, it should be fair. There is sort of a judgment to it. So what does it mean in this particular situation? So Mrs. Smith and Mr. Smith have been married for 50 years. Mr. Smith was recently diagnosed with a very painful terminal illness. He suffered greatly. He begs Mrs. Smith to give him sleeping pills so he can go to sleep and pass away. She does help him die, and he dies. And they determine Mr. Smith died of an overdose. Okay, so what is justice in this case? How would you decide what is just? So when you think about that, what is just? It may depend on what side you're thinking of it from. If you're a prosecutor and Mrs. Smith just killed somebody, committed a murder, what's justice in that case? And then if you're Mrs. Smith and you loved your husband and he was in excruciating pain, what is justice to you? So it's really important to think about justice as a balancing act. There are always going to be two sides to every issue when you talk about justice. It's always going to be this balancing act. So the question is, how do we determine justice then when there's always two sides? And the court has to always remember that often justice is seen in the eyes of the beholder, right? So different people can have different perspectives on what they actually think justice is. So you could have a result where somebody's like, that is completely unjust. And then you ask the other side, and they're like, oh, that was a great decision. And the courts have to constantly balance that. And they have to understand that all arguments have two sides. They have to analyze both sides carefully, impartially, blind. And they have to make a decision, knowing that the other side may say it's unjust. So they have to constantly balance those two things and try to determine what is most just. Okay. Now, one of the big things when you talk about the courts is this great debate about what should courts actually be doing. Okay, so we said that by the Constitution, they are required to interpret the laws. That is their constitutional duty, mission, to interpret the laws and to determine justice based on those interpretations. So there's always this debate on, does the court do more than what they're told to do? They're supposed to just interpret the laws. But some people argue that the courts actually make laws with their decisions. So some people argue that the courts tend to be policy makers. Okay, so when judges interpret the law and make a decision about the law, that interpretation could actually be creating an actual law. So for example, if I ask you about the Miranda warnings, you have the right to remain silent, you have the right to an attorney, where did those come from? And if you know, those came from a court decision. Miranda warnings are not identified in the Constitution. The actual rights are the Fifth Amendment, the Sixth Amendment, but nowhere in the Constitution does it say police have to read those to suspects prior to interrogation. It was the court's interpretation of it that made that determination. Okay, so a policymaker is somebody that makes a rule or law. And we said that we say that for the legislative branch, the legislation should create laws. But sometimes with its court decisions, the court is accused of making policies or laws, right? And here are some example. If they make change to race, they could make change to race relations by making certain interpretations of the Constitution, civil rights. They can overhaul the the juvenile system by requiring certain rights and procedures to be granted juveniles. So that makes policy for the juvenile courts. They can increase the rights to the accused by requiring Miranda. They're actually creating a law that gives rights to the accused. By prohibiting prayers or segregation in schools, they're creating school policy. Legalizing or criminalizing abortion is making a policy. Allowing the burning of the American flag, First Amendment rights of freedom of expression, equalizing school expenditures, impacts on prisons. So a lot of their decisions actually do make policy and have a ripple effect on the other parts of the criminal justice system, because they're making a rule that the rest of the system has to follow. So we talked a lot about at the beginning of the class, and you've been doing it in your papers, the rocking the boat. When the Supreme Court makes a decision that's a policy, it has a significant ripple effect into the other parts of the system that rocks their boat, because they may have to change what they're doing in order to satisfy this policy. Okay. Now, when we talk about the courts making these decisions, we want to think about how they do it, right? So Supreme Court justices are human beings, just like us. We hold them up for high regard. They're usually extremely intelligent. They usually go to Ivy League schools and are super smart. But how do they make their decision on what they want to say in their court cases? And it is often based on what we call their judicial philosophy. Okay. Now, we talked about before in other classes the idea of precedent and stare decisis. A precedent is previous decisions, and stare decisis is the idea that judges should follow what they previously decided to keep continuity with their decisions. But how firmly they follow those previous rules, or whether they change them, whether they make policies with their rules, are all based on individual Supreme Court justices' judicial philosophy. Judicial philosophy is their thoughts or feelings towards the law and how they carry out those laws. So I have a really good video that's posted, Judicial Decisions Crash Course, that you should stop the video and watch. And what it does is it explains judicial philosophy and how it affects Supreme Court's decisions. This is particularly important right now because we have people being appointed to the Supreme Court, and there's a constant battle between the Republicans and the Democrats and who should be on the Supreme Court. And a lot of times those decisions are affected by judicial philosophy. Democrats want judges with certain judicial philosophies. Republicans want justices with different judicial philosophies. So it's really a great little crash course to explain how significant judicial philosophy is when we choose who should be on the Supreme Court. Now, two of the big differences with philosophy is the difference between what we call activism versus restraintism, okay? So activism is the idea that generally you interpret the Constitution loosely, that the Constitution is a living, breathing document that should be interpreted with the times and adding current values and changings of society in your interpretation of the law. Traditionally, an activist judge is usually more liberal Democrat. That's traditionally how it's been. An activist judge is one that would be much more willing to make a decision that would actually create new policy, right? So you make a decision like Miranda, and that's creating a new law. That was considered judicial activism. Restraintism is different. Restraintism is the idea that you should strictly interpret the Constitution as it says in the Constitution, word for word. We should not be using modern values and concepts to interpret it. We should be using today or the Constitution as it was written. So we read the words, and if the words don't say it, then we don't interpret it that way. So restrainists don't believe in making policy. They don't believe it's the court's way to make laws. They believe that it should be just a strict interpretation of the Constitution. So you just look at the Constitution, you just look at what the founding fathers want, and you just follow that. They are also tend to be strict followers of precedent. So they don't like to overturn previous decisions. So in the past, restrainists were more conservative Republicans, really advocated for Supreme Court justices that were more restraintists. It's kind of interesting right now because we're seeing a little bit of switch. So our Supreme Court right now is really governed. The majority is Republican conservatives, which were traditional restraintists. But what you're seeing right now is those conservative justices going back and reversing precedent and changing previous decisions. And by doing that, they're changing policy. So it's interesting that the traditional conservative Republican judges who always believed in restrainism are now sort of moving towards activism in order to act policies that they believe in. So we're kind of seeing a shift right now in the court. And it'll be interesting. So there's a lot of big decisions that are out there right now. There's some decisions on gay rights. So there's previous precedent granting gay rights. There's interest in what's going to happen with those. Abortion is a huge issue right now. So Roe v. Wade is a over 50-year precedent that has been set. There's questions of whether this court's going to reverse that and change policy and act more activist and not follow that precedent. So we kind of live in interesting times to see where our court is going to go on these issues. What has happened is it has changed a lot over time. If you look at these two principles, during the 1960s, it was considered a very liberal court and it was considered a very activist court. So that was the warm court. So that was the liberal Democrat court, and they were very activists. So a lot of the constitutional protections for defendants, Miranda, the right to an attorney, all of those, the exclusionary rule, all of those big cases came out during this time period. The more conservative court or restrainist court was more considered the Rehnquist court. So the 80s and 90s, they believed much more in prior precedent and kind of firmly established laws. So it's interesting where we're going to go right now. And is the conservative court going to swing more towards being an activist court? So it's kind of turning everything on its head, all our traditional beliefs. Okay, so that is your discussion, or I guess it's your assignment for this week, is what do you think about courts and policy making? So I'm giving you a specific issue, the Guantanamo detainees and terrorism and all that stuff. And I want you to think about courts and their policymaking role and what they should be. Should they be more restrainist? Should they be more activist? Do they make policies? So all those concepts will be your homework for this week. Okay, that's all I have for the first lecture, and I will see you soon when I am back for the second part of this week.